And now, without further ado, the man of the hour, Councilor Woods, our legal update.
We have a great turnout here today, and I'm pleased, as we all are, to see that. The issues that I'm going to hit today are 4 issues. The first 2 relate to legal changes that are currently on the books that just occurred. We wanted to brief you on those as they're relevant to your business. The next one's a work in progress. It has passed, but it's being implemented. That's the NRRA. And then finally, we wanted to update you on the so-called Silvers case, which affects surplus line premium taxes. With respect to the first, the state has now increased its capital and surplus requirements for eligible surplus line brokers. This will go from $15 million to $45 million. It'll be a stepped increase. By the end of this year, insurers must have $30 million in capital and surplus, and then they must graduate by the end of 2013 to $45 million. We will be the only state that has codified this rule. New York follows an informal rule that is identical. They are attempting to codify it. So we're leading the charge on trying to up capital and surplus. We felt it was long overdue. I know Jerry Sullivan and Hank and others in the association took a look at the list of eligible surplus line insurers, and we found that probably 80% of the insurers already met that standard, and a number of others were within a few $1 million of meeting that standard, and we just think that it's the right level to meet in this day and age with more complex risk and such. So that's the first change. The second change statutorily revolves around the sharing of common directors in an affiliate insurer relationship, a holding company, for example, that has both admitted and not admitted insurers. And the tendency has been in the past to make sure that those who were directors of the non-admitted company could not serve on the board of the admitted company, because it could be construed that that would create a presence in the state of California by the non-admitted insurer, and that would imply that they were operating without a license. Additionally, there were certain services that the home office, if it were in California, could not actually perform because, again, it would give imputation of business done by a non-admitted insurer in the state. Well, we're pleased to say, after extensive discussions with the insurance department, we've come to a resolution of that so that one holding company can have common directors so long as those directors are not in the majority and those representing the non-admitted insurer are not involved in the management of the company. Additionally, there are certain clerical or administrative tasks that can be performed without jeopardizing the separation of admitted and non-admitted. Those include computer operations unrelated to the underwriting process, clerical and administrative staffing support, human resources, claims adjusting, and even managing investments. So there's a bit of a breakthrough there, and it allows a more efficient operation and presumably a lower cost ultimately to the consumer, so it makes sense from that perspective. The third point that I wanted to discuss is the NRRA, the so-called Non-Admitted and Reinsurance Reform Act. It's kind of bubbling up on your horizon now. It's been around since July of last year when President Obama signed it into law. It is due to take effect in full force a year later, meaning July 21 of this year. There's been a late flurry of activity at the NCOIL level and with respect to a couple of states that are attempting to put this off effectively for yet another year. Our inside thought is that that probably won't occur, but it's one of these to stay tuned. And what's causing some of the agita among the states is that a number of states have to amend their laws, most states do, in order to provide conformance to the NRRA. And they're struggling with that presently to try to make that effective. And also, a number of states are trying to conglomerate and figure out whether or not they want to enter into certain compacts, which is allowed under the NRRA, and whether or not those will be effective and when they'll be effective and what the terms thereof will be. So having said all that, The NRRA makes some significant changes to the national regulatory landscape for non-admitted insurers, in particular, the home state of the insured rules for almost all purposes. In other words, you're not going to have 50 states to deal with necessarily. You're going to have one state to deal with, and that's the home state. There are a couple of minor exceptions, but that's the thrust of this. Also, surplus line taxation is simplified. The regulation of non-admitted insurance, we hope, is simplified, and non-admitted insurer eligibility requirements, we too expect to be simplified. And I'll deal with each of these one at a time. Under the NRA, only the home state of an insurer may require any premium tax payment for non-admitted insurance. This is unless there's a compact with other states, but let's start with that because there are no compacts in existence today. Secondly, only the home state of the insured may regulate the placement of non-admitted insurance. And thirdly, only the home state of the insured may require a surplus line broker to be licensed in order to sell, solicit, or negotiate non-admitted insurance with respect to such insured. Any state law that conflicts with this will be preempted by federal law. And it's unusual to have a preemption actually written into a federal law, but there is one here, which gives it even more force than typically. The NRRA defines the term home state with respect to an insured as the state in which an insured maintains either its principal place of business or, if it's an individual, its residence. Now, no portion of the risk, if no portion of the risk is located in the insured's home state, which would be highly unusual, I believe, but nevertheless it could occur, the state to which the greatest percentage of the insured's taxable premium for the insurance contract will be deemed to be the home state. And if more than one insured in an affiliated group is named insureds on a master policy, then it's the home state means the home state of the member of the affiliated group that has the largest percentage of premium. So I would expect many instances, 90% of the cases, it's going to be the residence of the domicile of the particular insured. In a couple of instances, it will change. And we'll, I'm sure, have further discussion about that and educational programs to help bring you up to speed on that. For surplus line brokers, the NRRA simplifies the tax remittance and compliance requirements by requiring the broker to submit premium taxes to the home state. Now, classically in the past, you've been required to divide up on some basis, payroll or property exposure or liability exposure and the like, the taxes amongst the states. This is an attempt to simplify it. So you give it to the home state. The home state may ask you how you determined that, what criteria are involved, but they're not asking you to necessarily make an allocation. And then it's up to the home state, if they choose, to allocate this among other states. And they would do that presumably through a so-called compact. And we've borrowed from Jenny Craig and labeled some of our compacts Slim Pack Light, and which the industry tends to favor, and then NEMA, which the regulators tend to favor. There's a bit of a tug-of-war there going on as to which form of compact and reporting requirement may occur. From a broker's perspective, we want to make this as easy as possible. We want to take the burden off of you to be making these allocations that can be quite time-consuming and complex and interfere with your other good business. We want to make the states, once we pay our tax to a particular jurisdiction, we want to allow the states to divide it up and figure out who ought to have it. Now, I will also say that the likelihood of entering into these compacts is probably minimal, only because states that my mother used to say, possession's 9/10 of the law. Once the state gets 100% of the premium, I think they're going to be loath, premium tax, I think they're going to be loath to be discharging part of it to other states, unless there's some other reciprocal benefit that outweighs that division. So it'll be interesting to watch how this proceeds. It's very active now. And fortunately, we have on our team two of the nation's experts, Hank Haldeman and Jerry Sullivan. Hank leads the charge not only for us, the SLA, but also with NAPSLO. He's spent countless hours reviewing these issues, dealing with the brokers, and he has your interest at heart, and he's a very effective advocate, and we're just lucky to have him on board. And Jerry, too, with all of his background, experience, and connections. So we've got a great team working on your behalf to try to help simplify this, but also make it effective in your favor. Commercial purchasers of insurance, this is the new rule, are going to be exempt from diligent search requirements. However, immediately after I made that remark in California, Pat McCauley got a note and said, oh, that's effective immediately. I don't have to do diligent search. No, it's not effective until July 21 of this year. And there are a couple of course, little caveats. One is that the commercial purchaser there has to be a disclosure to the commercial purchaser that they can buy admitted insurance. And secondly, they have to authorize in writing that it's okay to purchase non-admitted insurance. And thirdly, and probably more importantly, you got to qualify. And this is basically for large insurers, those with qualified risk managers, $100,000 or more in annual premium, and meeting one or more of about 5 or 6 other criterion, number of employees, and a bunch of other things. So we'll give you more of a briefing and probably a bulletin on that so that you get a better handle on who might qualify so that you can skip the diligent search requirements. With respect to not admitted eligibility requirements, there's an attempt to make this simplified too. In other words, what non-admitted insurers are eligible to accept your risks. With respect to the aliens, it's quite simple. And an alien, of course, to refresh your recollection, is an insurer licensed outside the United States. If they are listed by the IID being the International Insurers Department of the National Association of Insurance Commissioners, on the NAIC's quarterly listing, you're free to use them. The states have no impact on that. So any company that's listed there, you're free to use. That's with respect to aliens. With respect to foreigners, the attempt is to simplify that as well. Instead of having a plethora of different standards that apply as to who's eligible and who isn't eligible, the simplification is we take a state may not impose an eligibility requirement on foreign insurers other than listed in NRRA, they being one, that it has to be licensed, the insurer has to be licensed in its domiciliary state. Pretend it's a Georgia insurer, it has to be licensed there, and for the lines that you're going to export the risk to. Secondly, the insurer has to have a capital and surplus of $15 million, which is the standard throughout the United States, or the greater amount of the state in which it is seeking qualification to write as a non-admitted insurer. In this instance, in California, ultimately that will mean $45 million. So you have those two criteria, and then other than that, we're just talking about the possibility of, again, an interstate compact that could change those rules. So there's a strong attempt to simplify. Where are we in the process? We've had lengthy discussions and meetings with the insurance department on behalf of the SLA. They've been very cooperative. There's been a lot of give and take, a lot of sharing of resources and the like. The last meeting we had by telephone yesterday lasted over an hour. And we've now more or less finalized the draft legislation that we're seeking to implement these in California. They will be introduced on February 18th. So that's right around the corner, and we're positive about this. And then finally, on the last item on the board, the Silvers matter, we're pleased to say that the California Supreme Court has now decided that denied the Silvers appeal. And what transpired there, to refresh your recollection, was that Lexington was accused of doing business in the state as a non-admitted insurer and should be subject not only to the surplus line tax but to the state admitted premium tax. And we as an association filed an amicus brief, produced Dennis Ward as an expert witness. He did quite well. And then this has worked its way up through the court system, and I'm pleased to say that no, the non-admitted insurer will only be subject to the non-admitted premium tax, not to any other taxes. So that should be good for your business. For any of those of you who are regulatory junkies, I have a set of the top 10 regulatory issues that we think will be affecting the industry, and you're welcome to pick those up afterwards. And I'm sure some of us will be hanging around afterwards if you have any particular questions. Thanks, everyone.
Thank you, Jim.